Guided choice dispute resolution differs from traditional design and construction mediation, largely based on guided choices focus on matters of process and the process that we use to get people on the same page and explore the possibility of early cost-efficient dispute resolution is what's often overlooked in traditional mediation. In traditional mediation, there's typically an agreement to mediate, but it often comes too late. It often comes late in the process, maybe after the parties have spent a couple years grinding through adversarial dispute resolution processes in court or arbitration, depositions, document exchange. The settlement discussion happens much later in time than it should. And you go forth next with, mediator selection, which, is probably unavoidable, right? We're going to need some sort of a neutral, whether it's a traditional mediation or whether it's a mediation using guided choice dispute resolution principles. But one of the mistakes that I think is made in traditional mediation is right out of the gate. One of the first things that happens after the mediator is selected is the parties select a date for the mediation. And that is because they tend to think about mediation as an event. It's going to happen on Tuesday, and it's either going to succeed or fail on Tuesday. And I think that's not the right way, in my view, of looking at it. I think dispute resolution for design and construction matters is complicated enough with a wide variety of psychological and organizational and other factors and impediments to settlement beyond the merits of the case that, if we think of mediation as an event that happens on a day rather than a process, I think we make a mistake, right? In both types of dispute resolution, the neutral is going to have confidential discussions with the parties, which I think is positive. I think one of the things that you see in traditional mediation is in exchange of what I'll refer to as legal briefs. We can call them mediation submissions or mediation statements. But I think that that's oftentimes a waste. And that's not because I'm against the exchange of information. Quite the contrary. It's because what people write about in their mediation submissions are just legal risk analysis matters that are generally not the things that are going to determine whether a principal in a design or construction firm is going to make a decision that their strategic best interests include settlement or, possibly to fight on in litigation. And I'm certainly a fan of all forms of mediation, but not at the expense of surrendering my client's best interests. We don't split the baby around here when we need to. We fight on, although in my experience, it's almost never the case that it's necessary to get involved in protracted litigation or arbitration if there's a sensible early cost-efficient dispute resolution promoting process in place early. Again, we wind up in traditional mediation having a date, having this mediation date. And so the parties are given the illusion that there's this event that's going to happen and something magical is going to occur on that date, when oftentimes the case just can't be settled on a particular date that's selected by the parties because it's going to require a couple rounds of the parties engaging with each other. And when we give the illusion of this event, expectations are not properly set. Parties might show up to the mediation, bang their fist on the table, eat a Danish, see the other party staking out an aggressive position and leave more angry than before. And so traditional mediation, the focus on, the idea of mediation being on a specific date or it being an event is a real problem. And when negotiations break down in traditional mediation, they often continue after the parties split apart that day, but often without much process to try to guide the parties and to get them closer together. And I don't mean shuttle diplomacy, let's just compromise. I mean, something drove the parties to say, I'm out of here. It's not in my strategic best interests to continue this discussion right now. There's an impediment there. Something is making them feel that way. The problem with traditional mediation is that these mediation events tend to break up without there being agreement on what's the process going forward for negotiations to continue. And traditionally, you'll see mediations many times end unsuccessfully. and then the mediator involvement ends. And that's, a cousin of guided choice dispute resolution. But I think that guided choice dispute resolution, again, is better because it focuses less on let's get this case settled, more on what is the process that's necessary to understand the stakeholders' real interests, what are the likely impediments to a settlement, how much information needs to be exchanged by the parties, and what is the process, right? The process being the key word for getting to this early cost-efficient dispute resolution. And so, the hallmarks of guided choice, which are, covered in depth in a dozen other videos that I'm going to be shooting momentarily, involve, early involvement by the neutral, right, the mediator. And the key word is early, before the parties are entrenched in their positions, before there's this animosity, before they spent a lot of money and they're looking at it saying, well, now I need to recover the money I've spent on legal fees in the course of any settlement, which is a mistake. Early involvement of a neutral, which is another way of referring to a mediator, is really important. So we're going to get the mediator involved at the earliest stages of the discussion, hopefully before any real money is spent on adversarial design and construction litigation. And then the mediator is going to address process issues first. We're not going to pick a date necessarily and say this is the day we're going to come together. The mediator is going to have confidential discussions with the parties. It's kind of similar to traditional mediation, but it isn't to try to figure out exactly where the parties should make their opening offer and what counter offers should be, because the guided choice neutral's focus is not so much on, how am I going to get this case settled, as it is on what makes the parties tick? Why are they at an impasse now? Is there something that we can do to get them past that? Is an information exchange necessary? Is an apology necessary? Does somebody need the catharsis of yelling at the other party? Are there cultural issues or gender issues or organizational issues? What is it that has brought them here now to me at an impasse? And, and then what do I need to do to break through that? And so, the mediator is going to investigate and diagnose why we are here and what are the potential impediments to settlement. What could we do to get past them, and design a process. And that's key. What's going to happen next? And it always, involves some information exchange, because typically when parties are unable to resolve a dispute themselves and they find themselves talking to a mediator, it's because, they're at, an impasse, and it's often because they don't have enough information, documents, and other sorts of information to be able to make a strategic decision about whether it's in their interest to settle or fight on. So what's the process design? How are we going to do information exchange? What can we do to anticipate impasse by the parties along this path? And then critically, no premature negotiations. And I think that's one of the most important things. And this is where I think that almost all traditional mediations that are lousy, at least the many that I've gone to that have been awful, fail, is the mediator will convene premature negotiations about settlement positions before the parties know enough to be able to make a decision about what is in their strategic best interest, i.e. settle or fight on. And then, in the event that the guided choice process doesn't get to a resolution, there needs to be an ongoing role for the neutral, at least in my judgment, because at this point, they know an awful lot about the parties. They know who the decision makers are. They've figured out a lot that could be constructive. And even if the parties decide that it's time for us to retreat back into these adversarial procedures, whether it's arbitration, whether it's litigation, there's really no reason in my judgment why the neutral shouldn't stay involved, but not just for a week or two, trying to bridge gaps, in settlement positions and doing shuttle diplomacy. Well, the parties' revised counteroffer is this and the other demand is this, but no, can they be more actively involved? Maybe they can, convene discussions of the experts, on a confidential basis to break through, impediments, or maybe, they can bring in a retired judge who isn't necessarily the judge in the ongoing litigation to, give an evaluation of the legal strengths of parties' positions when they're at odds over, well, my motion, of course, it's going to be granted. No, it's not going to be granted. So this ongoing role for the neutral that goes beyond shuttle diplomacy. I think is important because I think that in design and construction, most principals who own these companies are clients, most disputing parties, they want to negotiate a settlement. This is what they want, of course, without a surrender. We're not just going to, surrender for the sake of an early settlement, but they want to get rid of the dispute as soon as possible and not waste years and years on litigation support. And so one of the questions that you have to think about is how do you achieve a settlement when the other party shows no interest in backing off of a position that I've already, rejected? And, this is where process is important, right? And it's not to say that traditional mediations are bad. Certainly there are settlements that often come out of traditional mediation, but it's generally when the mediator is very well respected, perhaps an expert on substantive issues, or maybe when the offer on the table for one reason or another is sufficiently attractive. But if the mediation doesn't result in a settlement pretty quickly, the mediator is usually sacked. The parties resume this expensive and adversarial process of exchanging information through discovery and motion practice, but now things are worse, okay? The war is typically intensified, and the parties are frustrated by the mediator's failure to get the case settled, but often by perceptions of, a bad faith or at least obstinacy on the part of the other side for what the parties might view as, unfair tactics, maybe bad faith, a failure to engage, in good faith. The case is going to settle later on the courthouse steps, almost always, but it might be a year or two or three later, after the parties have exhausted themselves, squandering all this unnecessary time and resources and emotions and money that could have been spent in better ways, designing and constructing and bringing, to society these wonderful spaces that my clients create for all of us. And so guided choice, among other things, is this multi-phase process that involves a few phases of work before any negotiation occurs, right? We do not want to have this premature positional negotiation where party A says, this is my position, and party B says, this is my position, and everybody leaves angry because they're just, they're too far apart. They've taken these, diametrically opposite positions financially. And I think it's worth pointing out, and this is something that my mentor, Paul Luria, has driven home to me, is that, guided choice appreciates that parties are not necessarily agreeing to ever sit down and have a mediation. Just because they're willing to engage with a guided choice facilitator, a party's willingness to allow a guided choice facilitator to investigate and recommend one of these settlement processes, you shouldn't be perceived as an automatic agreement for the parties to attend, a particular classic mediation day. And I think that that's important. It's an important selling point, because if you're dealing with a party that's reluctant to mediate, as I often am when I'm trying to achieve this early cost-efficient dispute resolution, if I say, hey, will you please talk to this mediator that I know and just see whether, you're willing to engage his or her involvement, I'm not selling my opponent on the idea of let's have a mediation. I'm selling them on let's have a discussion. And then the decision about the when and the whether any real negotiations would take place facilitated by this neutral, it's part of the process creating. It's, one of the initial phases of the guided choice process is, does the reluctant opponent who I'm dealing with have enough faith that they're even willing to continue further and to see whether this neutral can facilitate discussions? Because again, it's all about devising process, identifying the reasons for impasse and how you overcome it.